So what are your options in court after being charged for a high-range drink driving? Once at court, you have one of two options. You may either plead guilty or not guilty. If you plead not guilty, your case will get adjourned to another day for hearing. The police will serve you with their evidence before the hearing starts. The magistrate will hear both sides of the evidence before deciding on a verdict of guilty or not guilty. Your charge will get dismissed and you'll be acquitted if you're found not guilty. The court will impose a sentence if you're found guilty. If you plead guilty in court, your case will proceed to sentence, usually on the same day. You should prepare well to try to get the best possible outcome. An early plea of guilty will reduce your sentence by up to 25%. If you need more time to prepare or for legal advice, you may ask the court for an adjournment to have your sentence heard on another day. You should prepare any necessary documents such as an apology letter, psychologist report, good character letters, evidence of the impact of a criminal conviction and licence disqualification will have on your job, you and your family dependents. For high-range drink driving, you can avoid prison, a conviction, and still keep your licence without a disqualification period even after pleading guilty. This can occur if the court gives you a Section 10 dismissal or non-conviction conditional release order. So what is high-range drink driving? High-range drink driving is categorised by the courts as the most serious kind of drink driving offence. It's when a person drives a motor vehicle on a road with a reading of at least 0.15 grams of alcohol in every 210 litres of breath or 100 millilitres of blood. What are the penalties? Disqualification and jail time for high-range drink driving. The penalties will depend on whether this is your first or second drink driving offence. It'll be considered a second or subsequent offence if you've previously been convicted of a major offence including drink driving within the last 5 years from the day that the court convicts you for your current high-range drink driving offence. Otherwise, it's considered a first offence. The maximum penalties for a first high-range drink driving offender is 18 months jail and or $3,300 fine, and a licence disqualification between 6 to 9 months, after which time a 2-year minimum interlock period under the mandatory interlock program applies. If you're excluded from the mandatory interlock program, there's an automatic 3 years licence disqualification unless the court's convinced to impose the minimum 1 year. The maximum penalties for a second or subsequent high-range drink driving offender is 2 years jail and or $5,500 fine, and a licence disqualification between 9 to 12 months, after which time a 2-year minimum interlock period under the mandatory interlock program applies. If you're excluded from the mandatory interlock program, there will be an automatic 5 years disqualification unless the court is convinced to impose the minimum 2 years. So what's the mandatory interlock device program? The mandatory interlock program will apply if the court convicts you for the offence, which will then require you to install an interlock device into the vehicle you intend to drive. Once the device is installed, the vehicle won't start unless you return a 0 alcohol reading after blowing into it. You won't be required to participate in the mandatory interlock program if the court imposes a non-conviction penalty under Section 10. Importantly, when deciding on the sentence to impose, the court will consider what the high-range drink driving guideline judgment says. For a summary of this, browse through our drink driving page here. Can you be exempt from participating in the mandatory interlock program? You can only be exempt from participating in the mandatory interlock program under Section 212 Road Transport Act 2013 New South Wales if you don't have access to a vehicle for the interlock device to be installed, you're unable to provide the interlock device with a sufficient sample due to your medical condition, but you can't be exempt from participating in the mandatory interlock program merely because of financial difficulties where you're unable to afford the expense of having the device installed and maintained, or merely because you won't be able to drive the motor vehicle in the course of your job with an interlock device installed, or merely because the owner of the vehicle doesn't allow you to install the device. So how can you get a high-range drink driving charge dropped, or how can you beat a high-range drink driving charge in New South Wales? This will occur if any of the following defences to high-range drink driving apply. If the breath test or analysis was done 2 hours after you last drove, if the police did the breath test on your private property, such as your driveway, if you held an honest and reasonable belief that you weren't intoxicated, a pharmacologist expert report concludes that your BAC was below 0.15 threshold for high range, the vehicle wasn't in motion and you didn't try to put it in motion at the time. If any such defence applies, an experienced drink driving lawyer can negotiate with the police to try to get the charge withdrawn early. Browse through our drink driving page for more information or call our 24/7 hotline to speak to a drink driving lawyer today. Thanks for watching.